Hello, I'm Robert Bejesky, and I'm an assistant professor in economics and law at Mid-Michigan College. I prepared a presentation for Constitution Day titled Assessing the Severity of Four Types of Impeachable Offenses. The presentation is based on my original research. I categorized the history of impeachment cases into a theoretical model. It asks the question for the viewer, what's the most severe category of impeachable offense? And there are history lessons contained in the presentation. I'll provide a little overview of impeachment, provide a framework of the history, and then discuss different types of impeachable offenses. Impeachment is a doctrine that exists in many democracies around the world. Democracy, meaning that citizens vote to select government officials. Impeachment says that if a government official commits a sufficiently serious wrongdoing, there's a procedure for removing the government official. That's the case, even though the population voted and selected that person for the government position. It normally gives one branch of government the authority to check and oversee the actions of another branch of government. It protects against wrongdoing. Here are a couple of caveats. First, impeachment and removal are two different things. Under the US Constitution, impeachment is a process voted on by the House of Representatives. In itself, it may just be a nasty stain on the record of the government official. Removal is the next step, which is the vote in the US Senate. It requires 2/3 vote. I'll mention the distinction throughout this presentation. Thus, with impeachment, the ultimate punishment is removal from office. In the United States, it's not a process in itself that's a criminal matter that puts the government official in jail. By contrast, in England, impeachment could lead to incarceration. England did sometimes combine impeachment proceedings with criminal penalties, and they sometimes imposed also on non-government officials. Second, keep in mind that it's not just political and government officials who are subject to impeachment, but also judges who run the courts. And one of the prime rationales for including judges is that federal judges are appointed for life and are not elected. Namely, because the doctrine of impeachment came from England, and England was the colonial power over America up until the American Revolution. And the time that the United States became an independent country, I'll consider cases that took place in England, how impeachment existed in the American colonies, and how it developed under our US Constitution. Here's a brief overview of the types of offenses and the analytical model that I'll keep returning to throughout the presentation. In my research, the types of cases fall generally into 1, a government official acting to usurp, to take political power of other branches in violation of the Constitution. 2, a government official using the power of the office for personal gain and corrupt purposes. 3, a government official excessively derogating from the proper functions of the office. And 4, a government official acting immorally, incompetently, or criminally in a manner that's intolerable for the office or offends the public interest. To categorize these 4 types of offenses, I have a graph. Because I'm an economics professor, we like to put things into analytical models to better understand what we're studying. This model is questioning what type of an offense did the government official or judge commit. Hypothetically, did the actor steal government funds, enter the country into war without Congress or legislative action, cheat on taxes, obstruct an investigation, or commit perjury? These are different types of offenses that may or may not be related to the government's official job. So here's the model. On the vertical axis, it's where another branch of government is involved. You know, democracies often have a legislative branch, an executive branch, and a judicial branch of government. At the top, another branch of government is involved in whatever the action the political official is engaged in. At the bottom, no other branch of government was involved in the government official's questionable action. The horizontal axis considers whether the government official or judge was acting in official duties. Was it the controversial action of the judge or government official related to their job obligations, or was it more personal in nature? On the left side, the official was acting in official duties. On the right side, the official or judge was not acting in official duties. The 4 categories of offenses can now be placed into our model. Number 1, taking the political power of another branch involves the government agent acting in official duties, and another branch of government is involved. Number 2, using the power of the office for personal gain and corrupt purposes can offend another branch of government. And if the official is seeking to personally gain and be corrupt, the official isn't acting according to official government duties. Number 3, excessively derogating from the proper functions of office does involve a person acting in their official duties, but it doesn't necessarily involve another branch of government. Number 4, a government official acting immorally, incompetently, or criminally doesn't involve another branch of government, and it isn't in the government actor's official duties. With this analytical model, the question I pose in this presentation is what category of offenses are the most serious and appropriate for impeachment and removal of a government official or judge? Records indicate that interpreting the U.S. Impeachment Clause and the type of offense that should be impeachable has been a fascinating inquiry since the U.S. Constitution was adopted in 1787. Every time a case developed, arguments fester over whether or not it's an impeachable offense. Before categorizing specific offenses, I'll explain the history that led to this development of impeachment to best relay the context of the American approach to impeachment and the reason the Impeachment Clause is contained in the U.S. Constitution. There are three eras discussed: English history, American colonial history, which is when England controlled America, and the post-colonial history in the United States. That means after the American Revolution and the adoption of the U.S. Constitution in 1787. England's impeachment proceedings trace back to at least the 14th century. Impeachment could be brought against government officials by the monarchy or the king or the House of Lords and the House of Commons. All three of these institutions still exist in England. The king or monarchy still exists in Britain, and it's not elected, but it's status. It's based on bloodline. On the other hand, the House of Commons is elected and is a lawmaking body like our Congress, but it's called a parliament. In the mid-17th century, England had a civil war, and there was a transition in power that shifted more power to Parliament and less to the monarchy. Impeachment played a critical role in this process. In the 17th century England, impeachment became perceived as a safeguard of public liberty because Parliament was able to employ impeachment to control the power of the king. The king lost this authority and was susceptible to grievances by the House of Lords and the House of Commons. It was a result of the Civil War in England. Parliament even began to utilize impeachment as a method of disapproving of the Crown's failure to communicate treaties to Parliament, waging war without consultation of Parliament, and to otherwise disagree with the Crown's foreign policy. Now let's travel across the Atlantic. When England was a colonial power over the American colonies, it appointed local governors and judges in the courts. Impeachment to remove government officials and judges had been regularly used to the English Crown's advantage, but the colonists began to use impeachment to tepidly challenge the English Crown. American colonists expressed hostility periodically in the first half of the 1700s that brought impeachment proceedings, sometimes challenging actions of British Crown appointees. The British Crown denied that colonial assemblies could impeach anyone because the Royal British Authority never granted the colonies with the right to impeach. But the American colonists eventually prevailed on the argument. John Adams maintained that the use of impeachment was a right inherent in free government, including under American charters. If one analogizes similarities between the British Parliament and American colonial governments as institutions more representative of the interests of the common public, the American colonists transgressed through a similar process and struggle as was faced about a century earlier in England. That was Parliament challenging the Crown. So across the Atlantic, descent to the Crown was a precursor to the American Revolution. Colonists complained that the King's charters controlled the colonies by establishing local assemblies. The English Crown appointed royal governors from England and loyal judges and issued legislative directives that prevailed over local colonial governments. Colonists commonly complained that public officials appointed by the Crown were greedy and corrupt and loyal to Britain. The American settlers wanted more political rights and freedoms and lawmaking authority. More detail on this will be discussed in the context of the first type of offense because this history unfolded in the context of impeachment offenses. That gets us to our third historical stage of the impeachment offenses. After the American Revolution, the framers included our own impeachment clause when adopting the US Constitution. The historical records affirm that the framers viewed the impeachment clause in the US Constitution as a critical protection to instill good behavior on the president. It protects American democracy. The US Constitution states that the president, vice president, and all civil officers and federal judges are subject to impeachment for treason, bribery, and other high crimes and misdemeanors. To repeat, it says the president, vice president, and all civil officers and federal judges. Federal judges are listed in here also because they're not elected and have a lifetime appointment. To date, at the national level under the US Constitution, over 60 impeachment proceedings have been brought in the House of Representatives. Of these 60 cases, less than a third were full impeachment and conviction proceedings. Of the 20 or so officials and judges who reached the Senate impeachment trial procedures, 8 were convicted, 8 were found not guilty. Also, 3 impeachment proceedings were dismissed and proceedings were not brought against 1. In most cases, though, those being investigated resigned or Congress chose to not pursue matters further. In other words, if an official or judge thinks a national, highly publicized impeachment proceeding could be brought, that threat was enough to compel a resignation in some cases. Many more judges have been impeached than political officers, which is logical. There are many times more federal judges, over 900 today, than the enumerated top executive branch officials. And if you consider the thousands of judges serving in the federal judiciary, it seems over history that the small number of offenses demonstrate that we have an excellent constitutional order and morally sound federal judges. Revisiting the language in the US Constitution, the Impeachment Clause states that government officials and judges can be convicted for treason, bribery, and high crimes and misdemeanors. The offenses with a clear definition listed in the US Constitution are treason and bribery. Treason is abetting a war or trying to overthrow the government. Bribery is using the official position to attain a personal benefit. High crimes and misdemeanors is interpretable. The framers of the US Constitution chose the language with knowledge of the precedent of impeachable offenses in England, which influenced the use of impeachment in the American colonies. The general phrase used by the framers, high crimes and misdemeanors, meant misconduct such as misapplication of government funds, abuse of official power, neglect of duty, encroaching on the power of the legislature, corruption, and betrayal of trust. It's the phrase that's often in contention every time an impeachment case arose in the United States. Because high crimes and misdemeanors has been an interpretable phrase, that's the reason for categorizing the four types of offenses in this presentation. The question becomes, how serious of an act does it need to be to impeach or remove these officials from their positions? That's the question I asked the viewer. But for simplicity, what I'm going to do here is avoid the details of the language of impeachment in England and the American colonies and under the US Constitution, and just talk about the fact patterns to highlight the offenses. Let's look at the four types of offenses. Here's the graph again. First, we're concerned about when an official or judge acts in their official duties and another branch of government is involved or attempts to take the political power of another branch. Here's one of the earliest impeachment actions in the American colonies. In the 1680s, Thomas Truman, a member of the local government assembly in Maryland, led a private group of militants against Native Americans, the Susquehannock. Maryland had been on good terms with the Susquehannock, but Truman led an offensive that falsely accused the Susquehannock for committing atrocities on the frontier. He was impeached and fined. A few years later, Jacob Young, an interpreter for Maryland with the Susquehannock tribe, was impeached and convicted of high crimes and misdemeanors for allegedly undermining Maryland's interest by being biased in favor of the Susquehannock in dealings with Maryland and for stirring rivalries among Native American tribes. In 1706, Massachusetts General Assembly impeached, convicted, and fined 6 individuals. We might call this the William Rouse et al. Case. William Rouse and others were charged with the treasonous crime of providing military supplies to the Acadians while England and the colonies were at war with the Acadians. And both houses convicted all 6 in a joint session. In 1798, and under the US Constitution's impeachment clause, framer Senator William Blount left his seat in the Senate and fled to Tennessee while the House of Representatives submitted and voted on his articles of impeachment. The events leading to Blount's exodus from the Senate was a letter dated in April 1797 written by Blount. President John Adams got his hands on the letter and demanded a Senate investigation. Impeachment charges included that Blount was involved in a conspiracy to assist Britain in its war against Spain, to assist Britain in overtaking the Spanish-held Floridas and Louisiana, and to incite Creek and Cherokee Nation of Native Americans to revolt against Spain in the territory. Blount's objective was to fuel the war between Spain, England, and the Native American people so that the Floridas would be left vulnerable and open for Blount and other land speculators to take it over. The Senate voted 25-1 in favor of expelling Blount from the Senate for being guilty of a high crime and misdemeanor, entirely inconsistent with his public trust and duty as a senator. Just preceding the American Civil War, Tennessee U.S. District Judge West Humphreys made secessionist revolt and rebellion speeches against the United States, made unlawful arrests, jailed Union sympathizers, and was impeached and convicted by Congress in 1862. Here are some examples of tampering with political affairs and undermining government without authority, such as American colonies challenging the authority and actions of British appointed judges during the 1700s, which the Crown resisted. In 1757, the Pennsylvania Assembly charged William Moore, an English Crown-appointed judge in Chester County, Pennsylvania, for circulating a petition to mobilize a militia to battle Native Americans, and the Assembly viewed this as an affront to its power. The Assembly also charged Moore with extortion, embezzlement, instigating frivolous lawsuits to charge fees, and neglect of duty. The Pennsylvania Assembly jailed Moore, but the British Privy Council ordered Moore's release, maintaining that the Pennsylvania Assembly usurped power that belonged to the British House of Commons. A little bit about the Privy Council. All decisions of colonial American courts and legislative adoptions were theoretically subject to review by the Privy Council in London. The Privy Council was an advisory and somewhat superficially autonomous entity, but one that served the crown. The Privy Council vetoed colonial laws and overturned colonial court judgments. It denied that the Pennsylvania Assembly had a right to impeach or imprison anyone for libel when this authority was a parliamentary privilege. The allegiance of judges became a key struggle between the British monarchy and the colonists that led to the American Revolution. I mean, after all, common law judges wielded significant authority, sometimes like a policymaker, and they were often allegiant to the crown. Impeachment was a way of ensuring that the judiciary wouldn't corruptly favor crown or English interests at the expense of the colonists. It wasn't just judges. England favored its loyal appointees in political offices. The English crown appointed John Harvey, governor of Virginia in 1628, and was knighted by Britain shortly thereafter. Virginians were skeptical of Harvey due to his close ties to Britain. He was a highly unpopular and he was viewed as tyrannical. The General Assembly of Virginia arrested Harvey and effectively impeached him. The Assembly accused Harvey of conspiring with and favoring traders from Maryland over interests in Virginia amid disagreements between the states, consummating a highly unpopular peace treaty with Native Americans and taking the side of the king against the colonists over unfair tobacco contracts. Harvey agreed to return to England to answer the charges, only to have King Charles I reinstate Harvey as governor. Now I'll take a step back and mention the Civil War in England to place it in the context of these related events in the American colonies. And this pertains to King Charles I. These events of the English crown dictating to the colonists were similar to what transpired a century earlier in England. The events that precipitated or even ignited the Civil War in England began in 1642, when King Charles I ordered Attorney General Edward Herbert to impeach 6 members of Congress, 5 of the House of Commons and 1 member of the House of Lords, for subverting the fundamental laws of England because they opposed the king's proclamations. After the House of Commons ignored the king's request, King Charles I went to the House of Commons accompanied by 400 soldiers in order to arrest the 5 members of Commons charged with impeachment, but the members weren't present. Instead, Commons retaliated by impeaching British Attorney General Herbert for defamation because he issued the charges that accused 6 members of Parliament for high treason. The Civil War unfolded, pitting supporters of Parliament against the monarchy, and the result was that King Charles I's military was defeated and he was executed in 1649. The English Civil War and what unfolded with impeachment was clearly a separation of power struggle, with the Parliament representing the people versus the crown. 2 other cases underscore the transition process in England and peeled back the foreign policy authority of the English crown. The political disputes involving Governor General of Bengal Warren Hastings in India, and the events that led the American colonists to revolt against the crown. Warren Hastings was the English crown appointed Governor General of Bengal, India. Hastings undertook an oppressive military strategy, was corrupt and abusive with governance in India, and led armed attacks that were retaliated by Indian colonists. That led the House of Commons to bring impeachment proceedings against Hastings. The House of Commons was reining in the power of the king. And another reason for the anger was that the East India Company lost a lot of money. The East India Company was a corporation that the British established to run colonial affairs and trade with India like it was a private company. Commons called Hastings' governance 10 years of multiplying disorder and abuse with his military exploits, endangering commercial advantages. At the same time, Hastings faced revolt against British colonialism in India. The American colonists revolted against the British crown in America. The British Parliament passed the Tea Act in an attempt to save the British East India Company from bankruptcy. The Tea Act imposed a tea on tea sold directly to the American colonies. The colonists responded by tossing tons of tea off of British ships, which became known as the Boston Tea Party of December 1773. The battle between the colonists and the British escalated. The British Parliament retaliated against the Boston Tea Party by passing punitive and escalating coercive acts in order to close down the port of Boston and keep colonial control. The British Parliament demanded that the East India Company be compensated for the destroyed tea. It adopted the Administration of Justice Act, which allowed British officials located in the colonies to be tried in Britain instead of in America, where they wouldn't expect to get a fair trial. England passed the Massachusetts Government Act, which placed the British government directly over the government of Massachusetts by allowing British authorities to appoint almost all government positions in Massachusetts. Britain authorized the Quartering Act, which permitted a British governor to choose buildings to house British troops because colonial legislatures weren't cooperative. In effect, the British reversed many policies that granted American colonial assemblies certain powers as they existed with imperial oversight and reservation for nearly a century. The response from the colonists was the American Revolution. In both India and the US, Britain's act of holding colonies for profit, keeping control over colonies against the will of the people, and oppressing the people led to revolt. Nearly a century after the United States had independence and had adopted the US Constitution, another battle over impeachment followed the American Civil War. In 1868, President Andrew Johnson was impeached but narrowly escaped conviction. It was the first impeachment of a US president. President Johnson violated the Tenure of Office Act by attempting to remove the Secretary of War, Edwin Stanton, without congressional assent. Johnson also delivered intemperate, inflammatory speeches against Congress and attempted to run and fund Reconstruction in the southern states in a way that was not consistent with Congress's law. That's why he wanted to remove General Stanton. Stanton was adhering to Congress's Reconstruction Acts. Johnson was attempting to reject the will of Congress. And since then, we've seen a lot of instances where Congress's authority has come into conflict with the president's commander-in-chief authority over the military. That's this first quadrant in this graph. I've summarized these cases in the first quadrant. Government officials took actions that undermined or violated the official authorities of another branch of government or government generally. The first quadrant conceptualizes the history across these different eras for the doctrine of impeachment. They were events that changed the course of history. What about our second category of impeachable acts? The category is called using the position for personal gain and corrupt purposes. There's still another branch of government involved, but the government actor isn't acting in official duties. At the core is the assumption that government officials should be acting in public interest and not personally profiting from a position of trust in government. This is the reverse side of the English Crown's view in the last section, where the Crown called the rebellion of the American colonists treasonous. From this new perspective, the colonists wanted government official loyalty to reside with America, not allegiance to England. The same reconfiguration of government power occurred during the latter half of the 17th century following the Civil War in England. The British Parliament viewed impeachment as a means of addressing offenses that were committed against the system of government. Parliament used impeachment inquiries to investigate the conduct of public officials and assess accountability for misusing political and government offices. Here are some cases in the colonies. The individual cases were often made more scandalous because newspaper articles stirred public ire. In 1766, a decade before the American Revolution, the British monarchy appointed Chief Justice Charles Schuyler, and he refused to hear cases unless they were submitted with the British government's royal stamps, which was at the objection of all the other justices on the court. Governor Charles Montagu wanted to remove Schuyler, but Schuyler died before the dispute was resolved. In 1774, the Massachusetts House of Representatives impeached Massachusetts Chief Justice Peter Oliver for accepting a salary out of the revenue duties from the Crown instead of receiving payment from the general court under the law. The belief was that he was loyal to the English Crown because his salary was paid by the Crown. Massachusetts framed the offense high crimes and misdemeanors and of a conspiracy against the charter privileges of the people. But when the impeachment referral was sent to the governor and council, it was never tried, largely because the governor was loyal to the Crown. But there wasn't just the assumed disloyalty from Justice Oliver due to the Crown paying Oliver's salary. Other substantive charges of impeachment included that Oliver corruptly perverted law and justice, undermined the Massachusetts Constitution and was so dictatorial with grand jurors that they refused to serve under him. Citizens were so angry that they insulted Chief Justice Oliver by hanging him in effigy and voiced umbrage with the governor and the royal government in Massachusetts. This example, shortly before the American Revolution, further confirmed the imperative of including an impeachment provision in the US Constitution. In the words of Hofer and Hull, authors of a noteworthy book on the history of impeachment, they said that John Adams, who was a chief advocate for the prosecution of Oliver, used Oliver as a symbol of advocacy for independence. This example reverberated across the colonies and was represented by the slogan that impeachment had toppled a government. With the further degenerating relations with the British just prior to the Revolution, there were other colonial impeachment movements concerned with impeaching Crown loyalists from their positions. Some were already discussed and others still to be addressed. There were many cases of impeachment for corruption under the US Constitution. In 1876, the House impeached, but the Senate did not convict Secretary of War William Belknap for his prostituting of his office for corrupt and private gain. He appointed a post trader and a military post in exchange for periodically receiving payments of thousands of dollars from the appointee through an intermediary. In 1904, the House impeached Charles Swain, a district judge in Florida, for appropriating hundreds of dollars in travel expenses, for filing false claims to the government, receiving free services on the local railroads, and residing outside the city of St. Augustine, Florida, in violation of his oath and an act of Congress. And he maliciously and illegally assessed contempt of court orders, prison sentences, and fines against parties to proceedings in his court. But the Senate acquitted Judge Swain. In 1912, Judge Archibald was impeached and convicted for profiting in transactions involving the subject matter of a case before him, not communicating facts to parties during pending litigation, and being paid a commission to effect the sale of a calm dump. In 1933, Judge Harold Louderback was impeached, but not convicted in the Senate for abusing his judicial power and being tyrannical, biased, and oppressive. Judge Louderback was accused of corrupt dealings, including by appointing favored attorneys in his cases and allowing inflated fees, taking fees in his cases for his personal profit, receiving a free room and expenses at the Fairmount Hotel to reside in the city while retaining a fictitious residence in another county to improperly have a trial removed. In 1936, Judge Halstead L. Ritter was impeached in the House on 7 articles and was found guilty on 1 article in the Senate. The articles included that Ritter allowed excessive fees charged by a lawyer in one of his cases, receiving a cash kickback from the appointed attorney, allowing excessive fees in bankruptcy proceedings to trustees, receiving cash kickbacks while failing to adequately conserve the assets of the companies in bankruptcy receivership, cheating on his taxes, and practicing law while on the bench. In July 1974, the House Judiciary Committee recommended that President Richard Nixon be impeached and removed from office. It was the first serious impeachment against the president since President Johnson following the Civil War. Nixon was investigated for using the powers of his office to engage in the cover-up and obstruction of the burglary investigation at the Democratic National Committee. He was also charged with infringing upon the constitutional rights of citizens with wiretap schemes. Nixon also misused the FBI, Secret Service, and other executive personnel in violation of the constitutional rights of citizens. Nixon obstructed justice, law, and constitutional government by failing to produce papers required by the subpoena of the House of Representatives during its attempt to obtain evidence to impeach the president. The crisis ended after members of his own party came to the White House and told him, "You will be impeached, convicted in the Senate, and removed from office." Nixon resigned. The impeachment charges that were working their way through Congress against Nixon also included obstruction of justice charge, misuse of executive powers charge, and contempt of Congress. There were a couple of other charges, including the secret bombing of Cambodia at the end of the Vietnam War and income tax invasion charges, but those didn't make it through the Judiciary Committee. Alcee Hastings, judge for the Southern District of Florida, was indicted in 1981 for soliciting a $150,000 bribe to reduce the sentence of 2 mob-connected felons, but Hastings was acquitted in a criminal court in 1983. However, in 1987, and after a 3-year investigation of the criminal case, the 11th Circuit Court of Appeals determined that Hastings committed perjury, tampered with evidence, and conspired to financially gain from bribes, Once the matter was referred to Congress, Hastings was impeached and convicted on 8 articles of impeachment for conspiring to reduce the sentence of a criminal defendant and lying under oath in his criminal trial. But he was elected to the House of Representatives in 1992. So impeachment in this case didn't disqualify him from holding federal public office in the future. At the end of 2019, the House of Representatives impeached President Trump for withholding hundreds of millions of dollars in military aid to Ukraine to fight the Russians. Congress had already approved the military aid. Trump was requesting a personal quid pro quo. The quid pro quo was that Ukrainian President Zelensky was required to announce that then President candidate Joe Biden and his son were being investigated for engaging in corrupt dealings in Ukraine. Under the Constitution, when Congress approves government funding, the president's constitutional obligation is to carry out the law and the funding. To withhold the funding in order to take advantage for personal gain is a form of corruption and can be bribery. There had not been any realistic indication within any U.S. intelligence agencies or units of government that there were any such corrupt dealings by Biden. There still hasn't been any proof of any corrupt dealings of Biden and his son in Ukraine in the last 2 years since Trump proposed the quid pro quo. It was an attempt to create a rumor that could circulate in the media, turn the public against Joe Biden, and eliminate him as a viable presidential candidate during the primaries. Joe Biden was later elected president, so it seems that he was the strongest candidate for president within the Democratic Party. The Senate didn't convict Trump after the impeachment by the House. Trump was impeached by the House a second time. This was for his involvement in the insurrection on the Capitol on January 6, 2021. Trump and his allies circulated unverified rumors about the election being stolen for nearly 2 months after the November 2020 presidential election. There were official verified results within all states confirming that each state's vote counts were valid and beyond question. Biden won by 7 million votes nationally and had an electoral college victory of 306 to 232. Trump's attorneys filed 63 lawsuits based on numerous false allegations and didn't present any evidence and frankly made very little sense. State bars are now investigating and considering whether to suspend law licenses or even disbar the attorneys who brought the lawsuits on behalf of the Trump campaign. Attorneys cannot file frivolous or false lawsuits. But based on these false allegations and advocacy on social media, Trump organized a Stop the Steal rally in Washington, D.C. on January 6th with many speakers giving inflammatory speeches. Those supporters then perpetrated an insurrection on the Capitol to try to stop an official constitutionally required proceeding to certify state votes for Biden's victory. Over 500 Trump supporters who stormed the Capitol have been arrested for crimes, including crimes of violence, for attacks on police officers, and destruction of government property. The FBI director testified before Congress 3 months later, on March 2nd, about what happened. Due to it being an attack on the Capitol with a political intention, the FBI director called it domestic terrorism. The Senate didn't convict Donald Trump, but 7 of the 53 Republican senators and all Democrats did vote to convict Trump. Here's an overview of these offenses in this second category. The category involves using a government or judicial position for personal gain and corrupt purposes. Government officials and judges are supposed to act in the public interest and not for personal profit. The government actor isn't acting in official duties, but there's an offense impacting another branch of government. Here's the third category of offense that's been subject to impeachment: the derogation from the proper functions of the office. That most commonly has consisted of allegations that a judge isn't being objective or is politicized when performing obligations on the bench. It falls between acting in official duties on the horizontal axis and no other branch of government being involved on the vertical axis. Common English precedent involved charges by the House of Commons against judges for committing dishonorable acts while sitting on the bench and administering laws. Many of the cases involved misinterpreting the laws. In England, in 1641, several high court justices, including Finch and Bramston, were all impeached because they traitorously and intentionally subverted the fundamental laws of England. They rendered judgments inconsistent with the law. In 1667, charges were brought against Lord Justice Keeling for high crimes and misdemeanors, for exercising arbitrary and illegal power because he undervalued, vilified, and condemned the Magna Carta, which is the British equivalent of our US Constitution. In 1866, Sir William Scroggs, Chief Justice of the King's Bench, was impeached for high crimes and misdemeanors because he subverted the fundamental laws, established religion, and government of England. For example, Justice Scruggs discharged the grand jury before their presentments, prevented the printing of a specified book, and regularly departed from rules of justice and equality and the imposition of fines upon persons that have been convicted of misdemeanors. In the American colonies, in 1681, the Pennsylvania Assembly impeached Chief Justice of the Pennsylvania Supreme Court, Nicholas Moore, because he had no legal experience, had received his position through an apparent purchase of the judicial position. He disrespected judges and did a poor job. In 1688, Seth Sothel was impeached for running the governorship in the colony of Carolina like a dictator, engaging in illegal imprisonment, extortion, interfering with the regular process of the courts, receiving bribes, and seizing the estates of several men without due process of law. One of the most famous cases in the United States of partisan bias in the impeachment process was the impeachment of U.S. Supreme Court Associate Justice Samuel Chase in 1804. The House of Representatives impeached him for giving speeches that were politically biased, delivering an unjust, arbitrary decision, and making errors as a judge. It was the highly inflammatory John Fry's criminal case that was the cause of impeachment. Even President John Adams called Fry's rebellion treason because Fry's led a band of men to Bethlehem, Pennsylvania, to jailbreak men imprisoned for failing to pay a dwelling tax. The deeper political issue was that the dwelling tax was a Federalist enacted tax policy. President Jefferson and other Republicans supported Fry's, and Federalists advocated for the prosecution of Fry's, which unsurprisingly was the same partisan division that unfolded with Republicans wanting to impeach Chase. Justice Chase was not convicted in the Senate, and he had a stalwart support from Senate Federalists. As an act of mercy, President John Adams did pardon Fry's. 2 centuries later, U.S. Supreme Court Chief Justice William Rehnquist aptly described that the process of impeaching Justice Chase backfired and ensured that impeachment would not be used in the future as a method to remove members of the Supreme Court for their judicial opinions, and this helped to safeguard the independence of the body. It does seem that with judges, there has since been a more self-regulatory approach to address grievances with poor decision-making or bias. It doesn't always need to go to impeachment. There were a couple of other cases that would fall into this category. For example, in 1830, U.S. District Judge in Missouri, James H. Peck, was impeached but not convicted for what was called a gross breach of power for jailing an attorney for 24 hours and suspending the attorney's bar license for 18 months because the attorney criticized the judge in an editorial about one of Judge Peck's decisions. Here's an overview of offenses that fall within this third quadrant. It's derogation from the proper functions of the office. It is most commonly involved claims of unfair and politicized judges and actions while serving on the bench. Here's the fourth quadrant of impeachable offenses. It involves a government official or judge acting immorally, incompetently, or criminally in an intolerable manner. No other branch of government is involved, and the official is not acting in official duties. These are personal conduct offenses. The framers of the U.S. Constitution intended for impeachment to remove officials for violations of public trust. The logic for this quadrant of offense is that immoral personal conduct could undermine the integrity of the office and be an impeachable offense. Crimes most commonly impeachable are perjury and obstruction of justice, which can be committed in official capacity. While the commission of both personal criminal and immoral conduct and highly incompetent acts in official capacity can justify impeachment, the latter presumably doesn't occur with a malicious or intentionally culpable state of mind. The precedent indicates that a government official committing criminal offenses may or may not result in impeachment. In 1676, the Maryland Lower Assembly impeached and prevented Charles James, the sheriff in Cecil County, for wrongdoing equivalent to perjury and obstruction of justice deriving from a land title dispute. James was accused of willfully and corruptly and falsely swearing under oath against Abraham Wild, a Cecil County commissioner. The delegates prohibited James from holding any other public office in Maryland, which was his sole punishment. In a 1706 case, the Massachusetts Assembly held an impeachment trial against Massachusetts Governor Joseph Dudley and an accomplice for wickedly managing and carrying out an illegal trade and several other accomplices for treason. The problem was that they were trading with the French at a time when England was at war with the French. But because these were criminal offenses, the process was eventually dismissed and criminal sentences were imposed. Here's a very noteworthy case of criminal conduct. Some of you may be familiar with this from history lessons or even the publicity surrounding the Broadway show Hamilton. Vice President Aaron Burr had just presided over the very tense political period of the pending Pickering impeachment case, which I'll mention in a minute, and would preside over the Chase impeachment trial in the Senate. I mentioned the Justice Chase case already. Vice President Aaron Burr killed former Secretary of Treasury Alexander Hamilton in a duel between the two impeachment trials. Burr was criminally indicted in both New York and New Jersey for murder, but was never tried and was never impeached. It seems that protecting one's reputation in a mutually agreed upon death battle match could still be an assumption of the risk defense for a criminal case, but by the Civil War, the practice of dueling to defend one's honor ended. The case of Judge Otto Kerner Jr. was an important precedent. Kerner tried to take advantage of a catch-22 in impeachment proceedings. For several decades, it was assumed that a criminal prosecution couldn't occur before an impeachment proceeding. In 1973, Judge Kerner contended that the constitutional impeachment process was the only means of removing a federal judge from office. It was also assumed that if someone was criminally convicted, there would be an effective removal from office and impeachment wouldn't be necessary because the judge or public official couldn't carry out his or her constitutional judicial obligations. Cutting through the smoke and mirrors, the argument suggests that a federal judge should be immune from criminal prosecution because he or she is a judge, but the argument failed. Kerner, the former governor of Illinois from 61 to 1968, resigned on July 24, 1974, obviating the need for impeachment proceedings. Kerner became the first of 4 Illinois governors since 1973 to be sentenced to prison. In 1984, Harry E. Claiborne, a district judge, was convicted of tax evasion and sentenced to 2 years in prison. In 1986, Congress impeached and convicted him on those charges. They did it because Claiborne never resigned, and he intended to return to his position as a judge after serving his prison term. Walter L. Nixon Jr., a federal district judge for the Southern District of Mississippi, was criminally convicted in 1986 on 2 perjury counts for lying to a grand jury about influencing a district attorney to delay a drug smuggling investigation of the business partner and a friend's son. Like Judge Claiborne, Judge Nixon didn't resign, and Judge Nixon continued to collect a $90,000 per year judicial salary after he was convicted. 3 years later, Congress impeached and convicted Judge Nixon. In the first case of a president actually impeached since Andrew Johnson in late 1998 and early 1999, President Clinton was impeached but not convicted in the Senate. Congress impeached President Clinton for procuring perjury and misleading testimony in the grand jury in the Paula Jones sexual harassment case against Clinton and on statements related to his relationship with Monica Lewinsky. A second article of impeachment was passed that stated Clinton obstructed justice by impeding, delaying, concealing, and covering up evidence relevant to the Paula Jones case. The basis for these articles of impeachment were that Paula Jones sued President Clinton for alleged sexual harassment while he was governor of Arkansas. Then President Clinton had a relationship with a White House intern named Monica Lewinsky. When this was revealed, the attorneys for Paula Jones and the special counsel investigator Kenneth Starr wanted Monica Lewinsky to provide evidence that would assist Paula Jones. So the articles of impeachment allege that Clinton tried to hinder Monica Lewinsky from providing accurate testimony in the Paula Jones case. In 2009, the House of Representatives unanimously impeached Samuel B. Kent, a judge for the Southern District of Texas. The House passed 4 articles of impeachment that charged Kent with making unwanted sexual advances in contact with employees, obstructing and impeding proceedings related to sexual harassment complaints, making false statements about that unwanted sexual conduct, committing the felony obstruction of justice, in which he pled guilty and was criminally sentenced, and making false and misleading statements to the FBI about the extent of the non-consensual sexual conduct. Judge Kent, who had been collecting a $174,000 a year salary while in prison, resigned before the Senate voted to convict. An impeachment and conviction cuts off the right to receive the judicial salary. In 2010, Congress impeached and convicted and permanently removed Thomas Portius, a judge for the Eastern District of Louisiana, for having a financial interest in a case, engaging in corruption, making false statements under oath, and committing perjury in his own personal bankruptcy filing. There are many very old cases of impeachment of officials and judges for gross neglect and incompetence. In 1768, Stephen Skinner, treasurer of the Eastern Division of New Jersey, was robbed of 6,570 pounds in colonial funds. And in 1774, the New Jersey Assembly investigated and imputed negligence for the loss. He resigned before there was any formal impeachment. In 1789, Congress impeached and removed Judge John Pickering. But the case is one of the most famous cases of impeachment. Is rather fascinating because it questions whether 200 years ago someone could be punished for having what might have been equivalent to a mental illness and potential substance abuse problem. Pickering was the Chief Justice of the New Hampshire Superior Court. In a property admiralty case, Judge Pickering rendered a decision in opposition to Congress's 1789 law that decreed ownership of the vessel Eliza to the wrong person. His decision didn't make any sense in light of the law that directly contradicted what he did. The House of Representatives charged Pickering with injuring the revenues of the United States and thereby impairing public credit, being totally intoxicated while on the bench, and frequently acting in a profane and indecent manner. So the Senate had a harder time with conviction because senators had to grapple with a difficult situation. Pickering maintained he was mentally insane and couldn't have intended any wrongdoing. Judge Pickering didn't appear before the Senate, so he was tried in absentia. The judge's son appeared before the Senate and offered a defense that he stated that his father was incapable of transacting any business which requires the exercise of judgment or the faculties of reason. Thus, Judge Pickering is incapable of corruption of judgment and can't be subject to impeachment or amenable to any trial for his actions. In fact, there were noteworthy witnesses who did testify and indicated that for several years, Pickering had some form of mental illness. Nonetheless, Pickering was convicted by a 19-7 vote in the Senate and was found guilty for each offense and was removed. One senator astutely remarked that if a person's sense of right and wrong are destroyed in the mind, that person can't commit a crime, but the person can be removed from office. I thought this would be a good case to end this section if you stayed with me this long. Here are some concluding points. Many government officials and judges serving in the British American colonial and the US were impeached. With such a comparatively small fraction of individuals impeached, one might contend that impeachment has not had a significant impact on democratic governance. This view is limited. Impeachment is an official, codified, and respected method of removal for transgressing acceptable behavior that provides an answer and procedure in the event of a constitutional standoff. It provides a warning device that in all likelihood preempts bad behavior. The threat of impeachment has persuaded the target of an investigation to resign, such as in the cases of like President Richard Nixon. There were undiscussed situations of impropriety, including a federal judge in Utah that resigned after knowledge that he was having an affair in the courtroom with the cleaning lady. Judge Kennesaw Landis resigned in 1921 under the threat of impeachment because he accepted the position to become the first commissioner of baseball, which compromised his judicial duties as a sitting federal judge. The Blount impeachment proceeding does seem to confirm that an accused cannot escape the impeachment proceedings by tendering a resignation prior to the proceedings. Specifically, for judges, Congress has also enacted laws that permit the judiciary to regulate itself so that the groups of judges, judicial councils, investigate, assess problems, and impose discipline on other judges. That has provided an alternative method for removal. It's self-regulation within the judiciary. But what about those types of offenses in the graph? Which are most serious? Breaking down these two variables again on the vertical axis of whether another branch of government is involved and on the horizontal axis of whether a government actor is involved in official duties, what is clear is that those offenses across the top have the broadest and most significant impact on protecting the integrity of government. Those at the top have more reverberating consequences. Those at the bottom are oftentimes individual offenses that don't broadly impact the laws or execution of the laws, but instead they predominantly impact the target of impeachment. But morality and good behavior is important for government officials. Bad behavior reflects poorly on the government. Quadrants 1 and 2 are at the top. Some offenses in Quadrant 1, from trying to interfere with government's relations with Native American tribes, supporting the Acadians, and Senator Blount's attempted divide and conquer to take Florida, had the ability to spiral out of control and cause a mess for the existing government. Consider how some of these other cases represented the ongoing constitutional crisis in England and the United States. The severity of the moment in England caused impeachments on each side in 1642, with Charles I eventually being overthrown and the House of Commons prevailing. Judge West gave secessionist speeches that preceded the American Civil War, and President Johnson unconstitutionally rejected Congress's Reconstruction Law following the American Civil War. The distinction with Quadrant 2 is that even though there's another branch of government being infringed by the impeachment action, the government agent was exceeding authority and trying to personally gain. The action didn't result from executing official actions, but the offense couldn't have occurred without the individual holding the position. Thus, there are many judges listed, from Shiner, Oliver, Swain, Archibald, Louderback, Ritter, and Hastings, all being accused of engaging in corrupt actions on the job for personal benefit. Using corrupt motives infringes on the integrity of government generally and the legal process. It's true that some of President Nixon's offenses, such as misusing the government and obstruction of justice, could arguably still be classified as acting in official duties. However, they were classified here because President Nixon was so clearly acting with corrupt intentions and self-interest. And the cover-up of the Watergate burglary did derive from his campaign's attempt to cheat in the presidential election. At the core, both of Trump's impeachments utilized self-interest that would undermine the integrity of the presidential election and the constitutional succession of power. Both Nixon and Trump were involved in obstructed congressional investigations. Quadrants 3 and 4 move away from impacting another branch of government, but one can always make arguments in this category that there were levels of varying impact on the executive or legislature. As one will notice, they're almost all judges. In Quadrant 3, which is represented by still acting in official duties, the commonality is that judges didn't follow the law or acted dictatorial on the bench. There are extremes. Justice Moore was biased and couldn't expect to be qualified or capable of deciding cases appropriately based on his background. U.S. Supreme Court Justice Chase was caught up in the political environment of the John Fry's attack on taxation. As for Quadrant 4, officials weren't engaging in acts that were related to official capacity. Looking at the individuals who were impeached, there's a lot of perjury. In many cases, there are underlying offenses, such as the land title dispute with James and sexual harassment with President Clinton and Judge Kent. And it's the false statements and obstruction of justice that cause or intensify the impeachment action. There are additional crimes that involve disrespect for the court system. Hence, there's another branch of government involved in the non-official act. As for Judge Pickering, he's hard to classify due to the behavioral issues. It's been my pleasure to provide this presentation. Thank you. Have a good one.